Bill, Blackhead, EMFC Loan Syndications LLC and Resort Group PLC.
Yes, Mr. Sweeting.
Yes, my lady, good morning. Can I just deal with a few slightly administrative matters at the outset? One of substance, though. My lady asked yesterday what Mr. Addington or EMFC knew of the TRG contracts. We think, having considered the matter, it's fairly set out in the judgment at paragraphs 13 and 14.
Thank you so much.
Which are pages.
Well, then I should have spotted it myself.
23. It's not obvious, I think, but that factual background is a fair summary, we think, of what in
13 and 14.
Paragraphs 13 and 14.
Yeah. Okay.
But he didn't actually see the contract. He didn't have the Investec contract that was signed in October, I think.
Yes.
October.
Thank you.
And then in relation to the question of what parts of the judgment are inaccurate in relation to quotes and emails,
Yeah.
I'm grateful to the learned friend who undertook the task of making the necessary changes. So can I hand up a copy of the judgment with some red additions which reflect what is in fact in the emails and the various things which are quoted.
Thank you.
Thank you very much.
I think both of us agree.
Mr. Allen did it.
Mr. Allen did it, so he deserves the thanks. He's instructed.
Thank you, Mr. Allen.
Probably.
I wasn't sure whether you were a learned friend or a learned junior. Your learned friend.
Oh, well, I was right to worry about paragraph 13 then.
Yes. Yeah, you were. Yes. Can I just take a moment to just see where that takes us? So 13 and 14 are significant. Well,
Not really, but I mean, it's
dear me, Mr. Allen, you've had a long night.
thank you.
Yes, that's very helpful. I'm prepared for suppose is probably the only substantive.
That's the only one. I think we're agreed all of the others are the consequence of the judge having read out and it being transcribed. Right?
And Mr. Allen held back from changing the result. Repudiation.
Yes. But we now know
You
that.
haven't added a not or a...
On the other hand, we can look for lots of punctuation changes for our judgments.
He wasn't quite so bold.
Yeah.
Yes.
Again,
Okay.
could I ask the court's indulgence just to hand up a second page of the extract from Chitty, which we find at page 6, because it struck
In the authorities.
in the authorities bundle. Yeah.
Yeah.
And we simply end that page with the title unequivocally.
You do.
And
Equivocally.
yeah. So it might be sensible if the court would
Okay.
insert the next page, which does deal with the question of an unequivocal repudiation and acceptance.
Thank you so much.
Yeah, which is relevant to it.
It is.
Thank you.
Thank you very much.
You want us to cast an eye of it? the footnotes, in the way this is configured, don't appear at the bottom. Aren't footnotes, are they? They're just notes.
They're end.
No, at the end of the chapter.
They'll be at the end of the chapter, yes, fine.
Yeah.
Of course they will be. But you're right, but we haven't got, have we got them? We haven't got them. Have we?
We haven't got 139, we've got 123 to 138.
Have we got the footnotes? Have we got these footnotes from this page, Mr. Sweeting?
Yes, I thought in fact the footnotes.
Oh yes, of course they are.
End
That's the-
notes.
Yes,
They're end notes.
Yeah.
Actually. They're not-
They are end notes.
Yeah.
In
Yes.
Chitty. So.
Yes, and so we. I see. Thank you. I'm being dim. Sorry, Mr. Sweeting. Good. Thank you. Yes. Right.
So just to recap, what I have to deal with today is a response on the repudiation
Yep.
point, a reply on the implied term effective cause point and costs. And I think
That's right.
it.
And then I forgot what I said. Then Mr. Allen will reply
On
on
repudiation.
repudiation. Thank you.
So may I begin then with repudiation
Yes.
and then go on to the reply? The first point to make perhaps is in relation to clause 1.2, and I don't need to labour this because you've heard some of my submissions at the outset. We simply say that clause 1.2 is an extremely unlikely candidate to be a condition in itself, and there was some discussion and exchange about that, I think, when I opened the contractual terms.
Yeah.
I think you've had what we want to say about it
Yes.
in the course of that exchange. Obviously, the important point is that if it were to be a condition, one would expect, given the consequences which are attached to the breach of a condition, that it would be clearly expressed as such. And in fact, clause 1.2 is more in the nature of a contractual statement about what should happen during the course of the contract. But
Well, and what's more, conditions are expressly identified elsewhere in the contract.
they are identified at clause 3. Of course, you've got that that slightly debatable condition which says compliance with all the terms of the agreement is a condition of the contract. But you probably know where that would end if it were to be debated as a condition in itself.
But this isn't in that section.
That's the
It isn't
point. It's
in
a matter
that
of
section.
construction.
No, and so the point the lady makes is the right one. If there are other conditions which are plainly important conditions and recognisably the sort of thing which would be a condition of this agreement, if this particular one at 1.2 was something the parties wanted to make a condition, it could have been put into clause 3. To get to in relation to that. So as far as breach is concerned, again, I think a lot of the law is really not in issue. It's its application, which arises for consideration in this case. But it is perhaps worth starting by saying that unless we've got an entire and indivisible contract, then the question is really, as Chitty puts it, this is at paragraph 24018, whether it's not a mere refusal or omission of one of the contracting parties to do something which he ought to do that will justify the other in repudiating the contract, that there must be an absolute refusal to perform his side of the contract. So unless you either have the hair trigger of a condition or an entire and indivisible contract where it's important to perform every single part as you go along, then that is the way in which Chitty sets it out, and we respectfully agree that must be the authors, that is the proper approach. And obviously if you get words or conduct which don't amount to renunciation, that will not justify a discharge. The only other point I seek to make is the point which is in fact made in Chitty at 24019, on the page that we've put in right at the top, is that the renunciation must be made quite plain. And again, that could almost be described as quite law in this area, because obviously there are significant consequences attached to renunciation. Whether there
Having made the point about the end note, am I right of that end note? No, I'm not. Have we got these end notes or not? We haven't got the end notes.
Wait, 6A.
1.139.
Yeah.
We don't have the end notes do we? The end notes that we have got are from Bousted.
Well, speaking for myself, I had different pages sent by email and we've had pages added. It would help if perhaps we had the relevant parts sent through, so we're not... I've just realised I got 2 6s because I was sent something by email.
Have you got the footnotes?
It doesn't help to be hopping about and not finding.
For my part, I'd just like to know the authority of that proposition because it's quite a plain statement.
Yes.
Thank you. Don't worry about it, Mr. Chapman. we can deal with it
As
later.
your lordship says, it's a quote from a case, so we ought to tell you what the authority is from which the quotation is taken.
That's really my point. Yes.
We'll do that. So the last point in terms of the legal context, which we say is important, is also in fact in the footnote 124A, but it's this. The question is whether there's been a renunciation depends on what a reasonable person would understand from the conduct of the party alleged to have renounced the contract and all of the circumstances prevailing at the time of termination, including the history of the transaction or the relationship. So that we say is the context, the salient points really from Chitty and from the authorities in terms of what needs to be applied to an examination of what is essentially a case about renunciation by conduct in this case. That means we need to start with what's identified as the renunciation, and we can do that by going to the email of the 16th of January 2016.
Tab 153. Page 153.
Yes. So I'm going to say something in a moment about the wider context, and I've touched on it yesterday in covering what the judge said about the factual background. But it's perhaps worth starting by noting that in copying this email, which was part of a chain, we can see that on the same day, Ms. Papasavu was in fact sending an updated board presentation, apologising for the delay with additional slides.
But she did that. She did that in the morning.
She did.
And was apparently all happy and all go.
Exactly.
And then perhaps left hand, right hand. Who knows?
Precisely.
Doesn't
But
matter,
but it's a part of the background. It's not at this stage any a case of any downing of tools, and that gives context to what I'm going to submit as the proper approach to looking at what Mr. Addington said at 11:39. Really, we can divide this email into the 2 substantive paragraphs, and we say that they are really in the nature of questions. And they are asking for a response. They are not stating a position. Obviously, that's important given the need for things to be quite plain, for there to be an unequivocal renunciation.
If we, in terms of the pleadings, which is what the judge went to at the beginning of his analysis on this, it's actually all about this email. That's the pleaded repudiatory breach, paragraph 9.
It is. I looked at the pleadings. I think a bit later on, the learned friend does say, in all the circumstances or in the premises.
That's very fair.
Uses the formulation
That's very fair.
on the opposite page.
Thank you.
That formulation does, at that point in the pleading, encompass, at the very least, the 2 meeting notes that we're going to turn to. But the lady is right in this sense that the starting point is that the defendant appears to be certainly nailing its colours to the mast of this being a repudiatory
Yes, you're right. So 10.5 in the premises, EMFC by Mr. Addington repudiated the contract, and that was after the end of the first conversation.
Yes. So he set out that he's made a reference in the amended pleading to the further conversations and the meetings. But I'll deal with those as I go.
Thank you, of course.
Okay. So just coming back to the email, I think looking at the wording, the first thing is that Mr. Addington is sharing his thoughts. That's the first thing we get. And then he says this in the centre of the first line: I would like to suspend, terminate our mandate and give Investec the chance to raise the money by itself.
Well, he actually says, the more I think about it,
Yeah.
the more I would like, and I'm stressing again words, Mr. Allen will understand that I'm doing that just to test your submission.
Yeah, certainly, yes. But
That's your point, is it?
well, it is the point. That doesn't...
It's an inchoate position,
Precisely, yes.
you would
Might
say.
be a good way of expressing that, if I may say so. So, and it's also, it's not only he's sharing his thoughts, it's put in that inchoate way, but he's also offering his thoughts in an advisory way as well. I mean, he's actually suggesting that this might be a better way of doing things. And we get that from the fact that he's not saying, I'm leaving in a huff, we're no longer prepared to do this. He follows on by saying, of course, we'll pass on all the contract names today, happily engage in 2 to 3 months when they fall, then they fail. So he's not envisaging a departure. What he's saying is, in the circumstances, and we'll come on to more elaboration of what they were, is this really going to work if we all go to Cape Verde together? Would it not be better, given where we've got to and the difficulties and other things we'll come to let Investec have a go?
Yes.
So that's the first paragraph.
That requires will being read as we would, doesn't it?
Well, yes. I mean, I think in vernacular speech, that's often, it's a bit like will and shall, isn't it, really? It's, we will do this if we're asked to do it.
Yes.
I think that's
I'm not sure that will and shall has survived emails as a...
No. Quite a lot hasn't.
Yes.
So then we go to paragraph 2, and this is
But
actually...
before you leave paragraph
Sorry.
1, and at the end, happily engage in 2 to 3 months when they fail. I mean, it seems to be options: suspend, and we'll come back in 2 or 3 months because they don't think Investec will work, or terminate and come back in. There are options given on there at the end of the email as well.
Yes, precisely. I mean, obviously it was open to either of the parties to terminate under the termination provision.
But it could be pause, not terminate.
It could be pause, yes, and suspend is much more consistent with that.
Yep.
I mean, one would, again, you have a flavour of the background, but the when they fail is obviously a measure in itself of the position to which the Investec and EMFC had got, certainly in the person of Mr. Addington. So then paragraph 2. So I'd characterise the first paragraph as being largely interrogatory. One might say that this one starts off really as a supplication. Can I please ask the team not to travel next week? Cost me personally, there's a little bit in the judgment about that. I do not believe we will close carrying such a dead weight. And I understand that Robert is Mr. Jarrett, is the proprietor, effectively, of TRG, is more closely engaged with Investec.
Closely engaged.
Yes.
Not more.
Is closely engaged with Investec. I think that was my commentary. I think the point is what Mr. Addington was saying, well, we think there's an inbuilt preference actually for Investec at this stage. We've reached a difficult position. It would be better if they had a clear run at the Cape Verde exercise that we're about to do. In any event, whatever, however one dissects what lies underneath that, it would be very difficult to say that this is a clear and unequivocal...
You say it's an offer to withdraw or suspend.
At most. And I think the other way of testing repudiatory breaches, which is often quite allegations of repudiatory breach, quite a good one in the business context, is to say, could the reply to this email be, you are in breach of contract, we are terminating the contract as a result of that breach, and we now have a claim for damages against you in relation to all the things that you were going to do but are no longer prepared to do. What would the reasonable person have said if that had come back? Well, we would suggest that the reasonable person would have said, well, that isn't actually what Mr. Addington was saying. You're quite wrong to take him as saying that as well. Would anyone in a commercial context think that Mr. Addington was doing something which exposed him to, or EMFC to, a claim for damages as a result of sending this email in these terms? So we say, can that really be the effect of an email in these terms? The judge didn't conclude that it was, and he was right to do so. If we go on to the note of the call, which we have over the page at 155,
I presume Mr. Addington was cross-examined on this conversation and gave evidence about it and all the rest of it. Yes,
he was. Yeah. And I'm going to take you to two parts in particular of the evidence of Mr. Addington that was accepted in relation to this. So this is
I do find it difficult that Mr. Scott wasn't present, because I know what the words on the page say, but it's like a transcript. It's the feel of the meeting and the feel of the conversation, but you will say that's where we are. He didn't give evidence, and that's the end of it.
I mean, very difficult, I think, given how much turned on this in the end, that Mr. Scott wasn't in a position to give evidence, but yes, that's where the judge was as well. Yes, yeah. And in fact, the judge was, of course, critical of Mr. Addington. He said he acquitted Mr. Addington of trying deliberately to mislead him or misleading him, and he also accepted Mr. Addington's evidence. So the judge certainly went through the evidence with care, the evidence he did here, and obviously he took into account all of the other evidence, documentary, and so on. It's also the case, one may think, looking at the judgment, the judge did pay, he was right to do so, particular attention to the contemporaneous material of these documents, whatever the difficulties were. You have to be slightly careful, of course, we would suggest, about the holding the gun to the head evidence and that sort of thing, because that doesn't appear in any of the contemporaneous material. Fair enough as commentary, which it was in the witness statement. But this was a reflection of what was in fact going on, as brief as these notes are. So if we look at this note, how do we characterise this? We would say this is the obvious consequence of that email. And indeed, it suggests that the email has precisely the character to which we ascribe to it, which is it prompted not the email which might have been sent, you're in breach of contract, we're in position to claim damages and so on. It prompted well, I think we need to talk about this effectively. What are the reasons? What are the underlying reasons you're saying this? And we get that. Mr. Scott is expressing surprise. That's what one would read, I think, naturally into paragraph 1, and wanted clarity about what the reasons were, not surprisingly, given that email. And then we get the summary. We need to read it through, but it's obviously addressed in particular to the position of Mr. Green and the difficulties in working with Mr. Green, because that's the second bullet point, which everyone agrees, however uncomplimentary it was, the reference to an idiot is to Mr. Green, and also to Investec's role. And it may well be this is a reflection again of the tension inherent of having two advisors, one really principally aimed at one market with its expertise and one at the other. And Mr. Addington saying he couldn't see how it could work.
Just before that, they are poised. IM is there, and we've got list of DFIs ready to go.
Yes.
So they is who?
That is EMFC.
And we is who?
That's again EMFC.
Yes.
It must be EMFC.
I'm
They're saying they're on the verge of doing the
assuming-
DFI deal. Yes.
I'm assuming that's right.
Yes.
Illustrates, again, how
I think
important Mr.
it's
Scott wasn't to give
difficult.
it.
I've read that essentially as Mr. Scott noting what he was being told, which
Yeah.
is that EMFC was poised to go. They got a list of DFI investments, and we've now got the information memorandum, so it's ready to go. That's the point. And of course, that fits in with the timetable as well in relation to the information memorandum.
Yeah. Sentence in brackets, or words in brackets then.
Suggestion of another job to do. I think that's a
Is in
slightly
brackets.
unclear one. I
Okay.
don't think anything came out of the judgment in relation
No.
to that.
But
So-
this note was it was all accepted by Mr. Addington, wasn't it?
Yes, he thought they were a fair recollection of what he was
Yep.
saying.
Don't need it.
And then we get the anyone to Cape Verde, even RA, Mr. Addington, no, underlined. I'll come back to that in a moment. And then 4, if decide not to use EMFC, will refund all fees paid and part as friends, but you'll come back. Which rather looks like the point my Lord was making about, is this a pause? What do you mean by they will fail, and we can pick up the pieces later on, that sort of thing. That was the sentiment that was being expressed.
And who is you, and you'll come back?
That is TRG.
So that's Mr. Addington saying, you'll be back.
You'll be back, effectively. Yeah. And we'll be here. So,
But what you say is, we will be here, we will complete our part of the deal, we'll provide you the DFI people, and we are ready to do so. And you decide whether you want commercial or DFI, but we think you'll pick us,
Yeah,
or
and-
you think you'll go with us.
yeah. And we have serious problems working with Mr. Green, particularly Mr. Investec. We have serious doubts about whether Investec can carry this off. And actually, we've got to the point where they can have a go. My prediction is they'll fail, but we can then come back to the DFI investments.
I mean, I don't want to be unfair, or it's not necessary, but I mean, in a way, this is working in conjunction with Investec. You can work in conjunction with somebody separately. You can decide in conjunction with Investec. The right thing for you now is for Investec to go first and alone. And then, do you see what I mean? It goes back to some of the points we were exploring yesterday. What does working in conjunction mean? The only contractual obligation is to agree tasks for Investec to agree the tasks in clause 2.1.
Yes, which is without. No, I absolutely see that. And
It doesn't necessarily mean you've always got to be around the same table
No,
at the same
no.
meeting doing the same thing.
No, and in fact, it's one of the points I was going to make a bit later on,
Sorry.
but I'll make it now, that there wasn't actually any stipulation about the contractual method of working that, for example, required you to be in the same meeting every time and in the same office. And given that you were actually aiming at different markets, lending markets, it'd be rather surprising if you were. And one of the things that we do know, Ms. Papisuva was a bit surprised that we were going to get a potential lender going to Cape Verde. That was unusual. It's referred to in the judgment. And of course, that sort of was the direction of travel then, wasn't it? That was an Investec commercial lending approach, and we know that that's actually what happened. So although Mr. Addington didn't think that it would, he was right in his way, was he not, to say, you go and see if Investec can do it, because that's plainly the way in which we're heading with this exercise, and that's what came to pass.
So you're saying the proposal to work sequentially was not inconsistent with working in conjunction?
No, not at all. And you would have expected, wouldn't you, someone with expertise. I mean, Mr. Addington had worked for Standard Chartered, I think. You would have expected someone with expertise to have actually said that the best thing to do now, surely, is to do the following. I mean, we accept it was expressed in terms which were really about the difficulties which had arisen. But that, of course, is the whole point, that the court has to look at this in the context of all the circumstances, and those are part of the circumstances as well.
Do you make any point about paragraph 5? I would call back later once discussed. Is that an indication? Do you say that this was a work in progress, not a goodbye and thank you?
Well, what it can't be is an unequivocal acceptance of repudiatory breach. So and the broader point that Your Lordship is referring to is yes, this was a discussion. and it was a discussion where reasons were being explored, the advice was being considered. I mean, if we stopped the narrative at this point with these materials, where could this have gone? The response could have been, actually, we think that's a good idea, so yeah, let's do that. We'll get back to you if it doesn't work out. And what we're about to come on to is the reason why the response was different, indeed why that in itself was quite surprising to Mr. Addington, because it wasn't what he'd envisaged. So perhaps I'll deal with that. I'll go back to the judgment as a piece actually later on, because I'm sure I don't need to make the point at this stage. Yes, so I'd call back once it was discussed. And then we do get the note on the opposite page on the same day, and we know helpfully that there had been that discussion and a decision to go with Investec, and the calls which were made to inform those who wanted to know.
So this was the following day, wasn't it? Because the 155 is a call on the 16th in the evening.
Yeah, it's mistakenly said
And
to be
then
17.
the next day
Yes.
there's the internal. Yeah.
Yeah. Sorry, it is misstated. I should have drawn attention to that.
Lady, sorry, this is still the 16th, so this is misstated as well.
Oh, is it?
Yes.
156 is also the 16th.
Yes.
Thank you very much.
Okay.
But is it after the... Yes, thank you very much.
Probably after.
Yes.
Yeah.
Yes. I mean, I think we have the sequential copying of the notebook pages a bit further on, so it's much easier to work from this transcription, but we've got them there.
Very warm in here.
So the absolutely crucial point
Yes,
here...
just a minute, Mr. Sweet.
It's all right. It's very warm in
Can I
here.
just
Forgive
have
me
a
for
word?
interrupting.
It's a bit warm in court. Is there anything you can do about that, do you think? Oh, it's... I'm, I could try to... Should I turn the temperature down, lady?
Well, probably don't.
It was absolutely on, very hot. So I'm turning
Thank
it down
you.
to between N and minus. I'm sorry. I do apologise.
Yes.
You see, so long since...
Well, no, it's the...
See, we don't have this problem with Zoom calls. Wouldn't have this problem on Teams. You see, we could adjust the temperature, each of us, to our own liking. Anyway, carry on.
It's, absence of water and the heat and the cold. It's a bit like being in the Foreign Legion at the moment. We're certainly suffering.
Sorry.
Not at all. So the second bullet point is really absolutely crucial in this analysis. Told Mr. Addington we'd been forced to make a decision given, and this is the point really, given the depth of feelings from underlined both sides. The point really that Mr. Addington had made, that this is not a good working relationship at the moment, and the intransigence and depth of feelings and irreconcilable differences. So this is precisely the point being acknowledged that Mr. Addington had made, which that there had been a breakdown of the relationship.
Yeah.
What then comes into the decision making are things which are not to do with what Mr. Addington was saying, but are really part of the internal and commercial decision-making process of TRG. Because in the TRG position was that this wasn't just about this particular fundraising initiative involving Investec and EMFC, but there was a desire for an Investec partnership in the long term. And that's what seems to have driven the decision making. And the decision itself, of course, is interesting in the way in which it's articulated, because the decision is to ask EMFC, Mr. Addington, to step aside. And it's not what Mr. Addington was suggesting in terms, but of course it's actually the practical effect of what he was suggesting, whether it's to step aside full stop, or whether it's to step aside for a period, which is really what Mr. Addington was putting on the table as one of the options. The view that had been reached in TRG was for the reason set out in the above point, that they should be asked to step aside. And helpfully, we then have a short note which really is in itself illuminating, because it goes to Mr. Addington's reaction to that. And the first reaction is why? not, well, yeah, obviously, we have nothing to do with you, intended that we shouldn't be carrying on. So, well, thanks very much. We've just got some financials to sort out. But it's why? Why are you doing this? Is our work okay? Do they actually think Investec can do it? Do they think Investec can do it? Etc. Really quite intrusive into our decision, which is what you would have expected if the decision was a decision which in part involved these long-term commercial considerations. Because from Mr. Addington's perspective, it is, well, yes, it's right, as you acknowledge, the relationship is breaking down, but we think we're in a position to do this, let them have a go, you'll come back to us in due course. So why? Don't really understand the decision. So intrusive into our decision, again, is a very interesting part of what we see memorialised as his relationship. And again, where do we get to? We don't even at that stage get to a complete separation following that decision. We get with left, I would call early next week, once I've considered the financials. I don't want to read too much into that because there's obviously a real dispute about the entitlement of EFMC at the heart of the case. But it's at least interesting to note that that was at this point the point of departure for the parties. So just pausing at that point, and really going back to my lady's point about what could be the basis for a renunciation. At this point, the decision has been made and has been communicated to Mr. Addington. Not, we would say, to accept a repudiatory breach, but to ask them to step aside for all the reasons I've touched on and won't repeat. So it follows from that that the rest, as it were, and by the rest I mean the later callback from Mr. Addington, can't involve anything that can be relied upon as repudiatory because the decision had been taken at that stage. I should actually have just made the point because it's not apparent that the 156 has a sort of blank at the bottom, but in the notes, what we see over at the top of the page, 157, just carries on. So the top of 157 is just a continuation of the bullet points at 156. So Mr. Addington repeating his offer to return all the fees and walk away. And I meet up with Victor and Sophie to explain decision. Yes, obviously that's meeting up to explain the decision to those to whom Mr. Addington was reporting.
And in the next one, it's Mr. Addington, is it, number one, who wanted to emphasise a strong handshake and friendly.
Yes.
Mr. Scott, it is Mr. Addington, that's agreed.
Yes. That's certainly how we understand it. I think that was the basis.
That's how the judge seems to have understood it.
Approached by the judge as well. So this is a postscript. It can't be the basis for any repudiation. We've covered the evidence in relation to the exchanges, apart from the evidence the judge also referred to in relation to what might possibly amount to a renunciation. But it's worth looking at that because, as your Lordship says, it starts with what might be regarded as a fairly inconsistent statement with the repudiatory breach, the idea that there should be an amicable parting, a desire to find out whether TRG were pleased with the work that had been done on the information memorandum, and also, and in the context of this case, perhaps of some note, the point that EMFC didn't have any form of intellectual property in the information memorandum or any contractual reason for saying that it couldn't be used by others, and the plain offer to transfer it across so that the travelling document itself, which was we've seen was still being iterated by Ms. Papasea, could be used going forward, as indeed it appears to have been from the judgment. And then a reference to trading fees, which gets us into the dispute about fees, which is at the heart of the case. And then a final comment from Mr. Addington, which is obviously directed at Mr. Green again, and picks up something which the judge had referred to as well.
It's the 4 words, need to pull out. What's that mean, or what did the judge said that meant?
Yes, I mean, I think it's a little bit opaque at that point. The point I do make about it is that this can't have had any bearing on repudiation.
Those are the words. You're anxious. Shouldn't have any repudiatory effect.
Anxious or not, I think
You teed it up in your previous comments about the previous page. Yeah.
whatever they mean. But again, I mean, even if one were going to say that, even if that could be taken into account, it would be a very slender basis for the plain words that are required for renunciation.
No, you know, I mean, these are not to be read like statutes or contracts, and this is both of you, no criticism at all, have basically been doing a mini rerun of the arguments. I mean, ultimately, it's a question of the judge's findings, isn't it?
It is.
Because it's impossible to get the flavour from the face of the document alone.
In fact, I was going to go
Yes.
to the judge's findings, because that is the jumping off point. I mean, the only point, looking at my note, I was going to make at this stage as a postscript to that is it did go ahead and the funding was obtained from Helios. So it can't be said that Mr. Addington's contribution to the debate was in any way disruptive of the outcome. It might or might not have happened. It's pretty clear he would have been prepared to take up the cudgels again on TRG's behalf had that been required. So 2 paragraphs in particular we would say deserve attention in the judgment. The first of those is paragraph 53. And I think the run into it is obviously 52.
Oh, 53. I was looking at 23, thinking.
Sorry, no.
Because I was looking at 23. Right, 53. Yes.
Sorry. I think just to set it into its context, we probably ought to start with 52 because it's obvious what we're picking up now. It's the communication of that decision to ask EMFC to step aside.
Yeah. So just for my own benefit, reminding myself that this 51 is the conversation between RJ, CK, AS, and LK, which is referred to at the top of 156.
Yes, it is. So that's the witness evidence, obviously, in the litigation context about the meeting.
52 is then the
note,
the note on 156.
Yeah. And the judge is referring to the call there, Mr. Scott to Mr. Addington. We've looked at the note of that. It's the decision note, if we can put it that way. And there's no dispute as to contents. Records the effect of the conversation with Mr. Addington, and insofar as it's material in these terms, the judge sets it out right the way down to stepping aside. Then, as Mr. Allen observed in paragraph 49 of his closing submissions, there is no dispute Mr. Scott told Mr. Addington that TRG would be proceeding from that point with Investec alone. Mr. Addington maintains that in the course of the call, Mr. Scott informed him that the claimant should not travel to Cape Verde. Mr. Allen challenges that in paragraph 51 of his closing submissions on 4 grounds. But in fact, they didn't get anywhere with the judge because he says, even bearing in mind the caution needed about Mr. Addington's evidence, I consider it probable that on this point he is correct. Whatever had been said by Mr. Scott and Mr. Addington in their earlier conversation on the 16th of January had been overtaken by the defendant's internal decision to proceed with Investec alone. Mr. Addington's expressed desire not to travel to Cape Verde provided obvious context for Mr. Scott to say what Mr. Addington alleges, and the decision taken by the defendant that Mr. Scott was communicating is entirely consistent with that being so as well. So if the most obvious thing which is pointed to as repudiatory, as an anticipatory breach, we're not going to Cape Verde, that wasn't the judge's finding. Mr. Addington's earlier email was raising those questions, asking for things to be considered. That took place, and there was no pulling out. So whatever the can't go means and the won't go in the notes, not quite that. That wasn't the judge's finding about it. And the obvious point is, by that stage, and it explains Mr. Addington's surprise, the decision had come back. No, we've decided actually we've got to We've got to resolve this problem by choosing one or other of you. Both of you, underline both, have difficulties, depth of feeling on both sides, etc. Then I think I submit we ought to combine that with the other really important finding about this, which is at paragraph 64. I think my learned friend said yesterday that it was a paragraph that he had to deal with, but he ended up in the course of his submission saying that it includes a finding that is contrary to other evidence. Now, I think we would say, perhaps he was running away with his submissions at that point, but it isn't open to a learned friend to attack finding in that way. It's not actually the subject of any permission.
Sorry, not the subject of any?
Any permission to appeal on an issue of fact that the judge got wrong. And in fact, it is entirely consistent, not only with the contemporaneous material and its proper characterisation, but also the finding of fact that the judge had made about the conversation we've just seen referred to at paragraph 53. So the judge says, I return to the defendant's pleaded case concerning repudiation. Reasons set out above do not accept that, as is alleged in paragraph 9 of the defence, the 16th of January email was a repudiation. I think the judge, starting on the premise that that was really what the case on repudiation was about, it was not a refusal to travel to Cape Verde in absolute terms either. For good reason, because obviously in the context of this case, that sort of refusal, if it was a requirement, you want us to go and we're not prepared to go, might well have been something which was significant. But we never got there for the reasons that the judge had explained. As I said earlier, I do not accept that in the conversation following, Mr. Addington said no one from the claimant would travel to Cape Verde in any absolute sense. The point being made was that in Mr. Addington's opinion, it was not in the defendant's interest that the claimant should travel to Cape Verde unless and until the difference between Investec had been resolved. And a perfectly fair observation, why turn up with two who were at loggerheads when actually it was much more likely that that trip was going to be about Investec and Helios and so on. The subsequent call following the internal discussion within the defendant's management shows that to be the defendant's understanding. We would say the judge is plainly right and certainly entitled to take that view. In my judgment, therefore, the repudiation defence fails. So we do say that the judge made findings of fact, which were clearly appropriate findings of fact to make, can't sensibly be challenged, and they clearly do not amount to a plain, unequivocal repudiation. In fact, they go the other way. The question really is, do they even amount to a breach, let alone a repudiatory breach of the contract? We would answer that question in the negative. They plainly don't. There wasn't a breach, let alone a repudiatory breach of the contract.
Thank you.
So, I don't think
What do you say about Mr. Allen's submission that there's false logic in the sense that the judge at various stages was proceeding on the basis that because TRG had a choice, there could be no repudiatory breach? He made that point a number of times.
Yes, I think the point he's making, the point, isn't he, really, that it wasn't the repudiatory breach would actually have brought things to a close at that point, and I think the judge was relying on the fact that TRG considered clearly that it has a decision to make, and that's how we would characterise it. I mean, there may be some overemphasis of that as a legal reason within the judge's analysis for reaching the view that he did, but actually what he had to do was to consider all the evidence in its circumstances, and to say that TRG, considering it had a decision to make, was entirely consistent with there not being any renunciation by the by EMFC.
Yes.
That's his point, of course, that neither party understood it to be. Now, of course, we accept that as a technical matter, the law doesn't require that. The court would be entitled to reach an objective view based upon the appropriate test as to whether the email of the 16th of January was repudiatory and whether it was accepted as such. But it would be highly surprising, perfectly proper point for the judge to make, if he concluded that neither party understood it to have that effect, i.e. we are refusing to work, we are refusing to we are refusing to go forward with the contract in a very important particular, that it was a renunciation. And that was essentially the point that the judge was making. And he did make findings, both as to what Mr. Addington understood, i.e. he wasn't renouncing, and how his email of the 16th was understood by the respondent. So I'll make this point succinctly, my next point, because my lady's already raised the point. Even if you have an unequivocal statement about refusing to work with Investec, that did not, in the context of this, for the Cape Verde trip, that did not, in the context of this contract, this engagement letter, deprive TRG of substantially all of the benefit the parties intended that party to get under the contract. Because, for these reasons, EMFC's obligations going forward extended well beyond even attending an important board meeting in Cape Verde. Even if there had been a refusal to work with Investec, that wouldn't have prevented EMFC performing its remaining obligations under the agreement. And we can see that from the indicative schedule of work and what is said about their obligations in the engagement letter. And the general approach, of course, is that a breach of contract is only going to be treated as a discharge of the contract if its effect is to render it purposeless for the innocent party to proceed further with the performance of the contract, because we are looking at the performance that lies ahead. Repudiation obviously doesn't go back to the start of the contractual relation in the way that misrepresentation does. So we're only looking at the performance which is yet to come. And I don't think I was going to perhaps just say a little bit more about the Mr. Green background. I suspect you have that well in mind, that I touched on yesterday, and the circumstances in which the difficulties had arisen. The fact that...
What background do we...
Well, in particular, the fact that as the judge says in his statement, TRG were prepared to give Mr. Green quite a lot more latitude than would otherwise have been the case.
That point.
Those points, and indeed the references to some of his personal qualities, which meant that he couldn't work with the person who, in fact, EMFC, Mrs. Papasevu, had put in place to begin with, as the person who, and was still doing the work as we saw from the 16th of January email. And that might have been considered as something which Mr. Green could have been taken to task with in terms of the willingness of Investec to work with EMFC. So that's the background. So Mr. Addington's email of the 16th really does have to be set in that particular context.
Thank you.
That's what I seek to say about repudiatory breach. If there are any questions?
Anything else?
No, thank you.
No, thank you.
Thank you very much. So now to your reply.
Yes, on
Effective cause.
effective cause. So So I just want to deal with the things which are properly the subject of a reply in terms of my learned
Yes.
friend's arguments. Firstly, just a very short point about the Silver Cloud case. One of the cases he put in,
Yes.
as we did at the start. We say it's very clearly a case involving the introduction of finance. So there's an obvious reason why that case is different from EMFC's position. And indeed, that also leads us straight into one of the other points he made about EMFC's obligations under the contract and being in relation to execution of the facility. Perhaps if we turn on to page 144 or 148, depending on whether we're looking at the typed up version or the original. This is the engagement letter.
Yes.
We can see that what my learned friend was referring to is, and I think he took me to this, to 2.1, EMFC's execution of the facilities.
Yes.
That was the point he was making.
Execution was the word here.
Execution, exactly. But
Underlined.
underlined. But that really is, we would say, in the context of this contract, something of a contractual shorthand, because the appointment itself at 1.1 makes it clear what EMFC's role was, and that's to assist in the execution of the facilities. So if my learned friend was really suggesting in these submissions that actually the role of EMFC was about execution of the facilities, that is not an accurate description of what the contractual role was. And in fact, we can see that as much as anything else from what we then see in paragraph 2 under the scope of the work. At 2.2, EMFC scope of work excludes a number of things. And then 2.3, the company, that's TRG, shall ensure that other members of the group, the TRG group, give any assistance which EMFC reasonably requires in relation to fulfilling its scope of work, including but not limited to. So what then comes at A, B, C, D, and E is an indication of what the scope of the work is, because this is what TRG has to assist in. And A is the preparation of confidentiality agreements, which have to be approved by TRG. B is preparing the marketing materials, and these were, they think, central. Company shall approve the information memoranda, the financial model, and any supporting presentations before such are distributed to potential lenders. That tells us what it was important for EMFC to be doing. And then C has to give information to EMFC in connection with the facilities, including copies of the relevant files, working version of a business plan, technical diagrams, pictures, logos, and so on. D, to make available effectively the time of senior management and representatives. And then E, and this is perhaps an important one in its context, using best efforts to ensure that the execution of the facilities benefits from the group's existing lending relationships. So that gives us a fairly good summary, because these were the important matters that TRG had to assist EMFC with, of what EMFC were in fact required to do. And it certainly is it's a very long way away from finding and introducing a lender, for example, in the Silver Cloud type case. It's also quite different from saying it's execution of the facilities. It is in fact assisting in the execution of the facilities. We also get, don't we, I taken you to it before at 152, the indicative scope of work which is set out in the schedule. So, my lords, that's what we say about the execution point. My then friend also made a point about the clear market provision, which we had relied on.
Yes, he says that supports his case, not yours.
Exactly. So his case in relation to that was, well, why would you, if your case, EMFC, is that come what may, effectively you're going to be entitled to your completion fee. Why wouldn't you have wanted as many people as possible to be working on this? Because that surely would have raised the prospects of there being some outcome from which you would have benefited. I think that's the way in which he was putting it. So you wouldn't have wanted a walled garden, you'd have wanted a completely free market for TRG to go and employ as many people as possible, because on our case we're going to get the completion fee and so on. What that overlooks, of course, are 2 points in particular. The first is that in the position of either Investec or EMFC, what those bodies are doing is their normal work in the marketplace, in which they back themselves, obviously. And there are 2 points that follow from that. One is that you do not want others involved in the attempts to raise finance if those might in fact scupper them. If you have a delicate market, for example, you do not want lots and lots of people coming in and potentially acting at cross purposes, approaching the same people as you're approaching, doing the same work as you're approaching, and so on. That's the first point. The second point about clear market requirements is that there is in fact an intrinsic value in being the party that works with TRG in order to secure the financing deals. Obviously, in this case, it was the two-pronged approach. It's either going to be commercial lending or development finance. But you do not, in fact, want to be in a position where you simply say, well, we're going to do nothing now. It's a sort of recycling of the Clause 14 argument. We can just sit back now and we can wait for others to do the work, or we can welcome them to do the work. You want to go on to the next deal, being able to say, well, we put this to bed for TRG. Because that's your work, that's your business. And that's why if you are given the opportunity to do this, you want the opportunity to do the work. And the assumption that actually what you would be quite pleased to do is simply sit back and share in the benefits wouldn't get you the next contract, wouldn't actually be a commercial enterprise if that was your approach. The short point is you don't get any credit for goal hanging, and that would be precisely the effect, in rather vernacular terms, of what EMFC would be doing.
So vernacular, I didn't hear them properly. Sorry.
I said you don't get any credit for goal hanging. That was the point. You don't want to say, well, it's an easy goal. You want to be the person who runs up the pitch, beats all the defenders, and puts it in the back of the net.
You get a higher transfer next time in Manchester City, won't you? Yeah.
And it's on the TV. It's on the.
Let's be back
to
to analogies, yes.
So that's what we say there. It's another one of those arguments. It's a bit like the Clause 14 argument. Well, you could have given notice and just sat back and taken your fee. That actually wasn't what this was about, and it's not what it's about in commercial terms. I think. Well, those are the points I picked up for the purpose of a reply. If there are any others, I'm quite happy.
On effective cause.
On effective cause.
Yeah. Thank you.
Thank you. Do you want to say anything on costs?
I don't want to say anything on costs. Thank you.
Thank you very much. Thank you. So, Mr. Allen, finally back to you for your reply on the cross appeal repudiation.
Well, look, one thing that has emerged is I have a different football philosophy to my learned friend, because I always quite enjoyed goal hanging. I thought they were the cleverest players on the pitch.
Did you watch any of the goals last night?
Of course, I was working very hard.
Yes, of course you were. You were redliner. There was some,
Not as effective as the
very
goals.
good goals last night.
Not as effective as the goal at the weekend, but anyway, that's from the goalkeeper. But meanwhile, back at the point.
Back to the point. I will try to be as brief as I can by way of reply, because I was given indulgence by the court yesterday to make lengthy submissions about renunciation. The first point I was going to make was in respect of a point which Milady raised about the fact that in the contract certain
Conditions
were identified as conditions. Yes. And of course, I mean, you will have this point.
Oh, that's not on the cross appeal. Oh, it is. Yes, it is. Yes, it is.
On everything.
Yes. On the authorities, it's clear that labels are not definitive.
No, I'm sorry.
And when parties are legally represented in drafting contracts, then labels are given more weight. But in a contract like this one, where neither party had legal representation.
Okay.
At best, part of the material, but not definitive. Then just quickly on the law as well, my learned friend took you to the extract from Chitty at page 6 of the authorities fund.
Yes. Do you want us to go back there?
Yes, please.
He's called it 6.1, I think.
In fact, no. It's actually
The 6
was already there.
Okay.
And he mentioned the earlier part of paragraph 24.018 when talking about what had to happen to renunciation. But I just draw attention to the final part of that first paragraph. Also, the party in default may intend in fact to fulfil the contract, but may be determined to do so only in a manner substantially inconsistent with its obligations. And that footnote links to the Smith case, which I safeguarded.
That's right.
And I say that's the position in this case.
Okay.
I agree with my learned friend that the test for renunciation is that it has to be unequivocal and it has to be appear in that way to a reasonable person in the position of the parties and with the knowledge of the parties. But of course, what I say we have in this case is an acceptance by the judge of TRG's evidence as to how they interpreted the relevant facts. And I took the court through that yesterday. I won't labour that again, but I took you to Mr. King's evidence, which the judge accepted. So the court, in my respectful submission, did accept that evidence.
But the fundamental problem for that is, for you, it seems to me to be paragraph 64. If you're relying on what the judge's overall interpretation of the evidence was, that's where he actually reaches his definitive conclusion on it.
My Lord, I accept that is a key paragraph, and what I would say is in that the judge, in saying what he says there, refers again to the internal discussion, the subsequent call. So the bottom of paragraph 64, which is at page 34, says the subsequent call following the internal discussion within the defendant's management shows that to be the defendant's understanding. So again, he seems to be relying again on what the defendant's understanding was. So this feeds back into the point I was making a moment ago to the court, is that it appears the judge accepted TRG's evidence as to what their internal understanding was, and that's the evidence I took you to yesterday, which is inconsistent with the conclusion the judge is reaching in this paragraph. And so I say what one has is, in my respectful submission, a clear acceptance of the evidence as to what TRG perceived the position to be. The question is that a reasonable view for TRG to hold? And I say it is for the reasons I outlined in detail yesterday. And I take the point that was made earlier about construing emails and notes of their statutes. But given that there was some discussion about parts of them, with the court's indulgence, I will just make a few short points about them. Looking first at the email, which is at page 153. Just to respectfully adopt a point which was raised by my Lord Justice Baker about the effect of the word will. That is a definitive statement as to what will happen.
Well, I was suggesting that
it might be.
That on Mr. Sweeting's interpretation, we'd have to read will as would, and that's the point where he made his observation about loose language in emails.
Well, my Lord, I accept that emails are not to be read as statutes, but I repeat the submissions, the broad submissions I made yesterday about the effect of.
Yeah, but it could be said that one should read into that sentence before the words "we will." In that event, we will.
Well, my Lord, and then I would come back to the interpretation again. I don't want to repeat the point I made yesterday about the sentence which precedes it, about the options being given do not include working in the future with Investec. And I take my ladyship's point that was made earlier about what does working in conjunction mean. But we know it means agreeing tasks with Investec because that's clause 2.1 of the contract, and we know it had been agreed and anticipated by all parties that EMFC would attend the important meetings in Cape Verde, and we see that in the judge's findings that it was meetings were organised between very eminent people in Cape Verde and EMFC. So that was part that. Insofar as there's any doubt about what working in conjunction with Investec meant, it certainly meant travelling to Cape Verde and attending those crucial meetings. So, my lord, I say that when one is considering that phrase in conjunction, one must look at the entirety of the background. I won't repeat the other submissions I made about that email yesterday. Just looking quickly at page 155. It was said that Mr. Scott was asking for clarity, and that was suggested, I think, that was a suggestion that the effect of the preceding email was not apparent. In my respectful submission, it was a sensible thing for anybody to do, to check they had not misunderstood the meaning of an email like that. And we don't rely solely on the email, we rely on the email and subsequent conversation. Mr. Scott asked for clarity, and in my respectful submission, Mr. Addington gives it to him for the reasons I've outlined when discussing the note yesterday, saying he can't definitively work with Investec.
So at what point was the repudiation communicated? Was it not the letter, the email? At what point?
It was the end of this.
The end of this first telephone conversation.
My lord, yes.
Right. That's okay.
That's my point. And just to come back, my Lord Justice Lewis mentioned a point about paragraph 5 about should you read anything into callback once discussed, and I think that ties in to the point I made yesterday about you all have a decision to be made when somebody is presenting you with an anticipatory breach of contract. So there's nothing surprising or inconsistent in my respectful submission about that particular line. And I think the final point was at page 157. And this follows on from the answer I just gave to my Lord's question. We don't rely on this conversation as a renunciation itself, but we do say it is important in showing what the parties understood had happened at the material time. And Mr. Addington understood, as recorded in this conversation, that he needed to pull out. He'd been the one to pull out. So just to be clear about the way we put our case about that particular conversation. Excuse me. My lady, unless there's any further.
Really helpful, thank you.
Thank you very much, Mr. Allen.
Oh, sorry. Can I ask something? Nothing to do with the merits of the case as such. I'm interested in the timetable of this hearing. We had a day for the judge to read, I imagine. There was a reading list. And then day 1, day 2, day 3. Can somebody help me how it panned out? Please, Mr. Chapman. And Mr. Sweeting, I think you're off the hook on that one.
Thank you. Shall I go first with my recollection?
Please.
My recollection is that there was some reading time on the first morning and then a short opening, and then this box first. No reading.
Do you mind? It's important. Important for us, yeah.
On our side, we don't. On reflection, we think perhaps there wasn't any reading time, and the judge went straight into the case.
But you must have pre-read the night. I mean, so normally, so the shorter trial scheme, up to 4 days, including 1 day reading. So was he given a day to read? It must have been. He obviously had skeletons in advance,
yes.
Did he? Written openings, and presumably a reading list.
Yes.
And a time estimate for that reading.
Yes, and he indicated when he came into court that he had read it and had thought there was some other case. There was another case on effective cause, I think, which he had done. So he had obviously
Thank you.
I think he pre-read and then he took on with it.
Yes, yeah. So he'd certainly done pre-reading. He'd certainly read to get an argument.
Right.
He
So you go in at 10:30, and Mr. Chapman opens the case for an hour.
There were written submissions in advance.
Yes.
And my solicitors think that Friday, in fact, before the Monday, was the reading day.
Right. So Friday's the reading day. Monday morning, 10:30, suited and booted, 1 hour opening, short opening of some sort,
Yes.
and then who goes into the witness box?
I believe it was Miss Papa Suffolk.
Yes, and then Mr. A. Anybody else?
and Mr. King, but that was on. So were we talking? So on day one, it was just Miss Papasava, I think, wasn't it? Miss
Right.
Papasava. No, Miss Papasava, Mr. Addington, and then I think Mr. King on day two.
So Mr. Addington was finished on day one as well, was he?
I think he was.
Mm-hmm.
It was.
So day two, Mr. King.
And then there was a debate about whether, because there was a witness summons in respect of Mr. Scott. Until very late before trial, it was anticipated he would attend. There was a witness statement. You've seen there's
Yeah.
an extract to it in the bundle. Relatively late before trial, he got another job which required him to go travel abroad. And then a day before trial, we were told actually he wasn't going to be abroad on the day of the trial. So we issued a witness summons, and the judge, then because it was so late, the judge had to expressly grant permission for it to be
Issued.
served.
Yep, served.
And the judge looked at it and observed that he didn't think it was Mr. Scott's evidence was going to be necessary or determinative in respect of the case, and so in the end the witness summons wasn't served.
I see. And it went in as hearsay.
Went in his
So
head.
Mr. King gives evidence for what, half a day?
Yes, around that, and then there was time for the parties to
So
prepare.
that afternoon you prepare written closings, come in on day three.
Yes.
Lady, I'm just looking at Mr. Chapman's opening skeleton,
Thank you.
which said there was an agreed timetable, a statement of issues, a chronology, dramatis personae, and Mr. Chapman suggested reading of pleadings, statements, the engagement letter, and documented correspondence. And the judge was told that there would be 2 witnesses for each side with no experts.
Lovely. And time estimate did Mr. Chapman? He may not have done. Doesn't matter if he did. But
Listed for trial under the shorter trial scheme over 3 days.
And pre-reading time estimate.
Don't
No, it doesn't matter.
think,
Very helpful. And then you referred yesterday, Mr. Allen, to how much evidence, how many bundles there were on effective cause. How many trial bundles were there?
My recollections, there were about, I think, 8 bundles. I think it was 8 bundles. I think there was. Remember the core bundle, the C bundle of documents was 6 files.
It's core bundle 6 files.
Sorry, no, it was C, so it wasn't core, but it was.
It was
C,
T, I
but
think,
that
in
was
the notes.
documents. So it was.
Yes.
It was 6 documents bundles and a pleadings bundle, I think a witness statement bundle. So I think the pleadings and witness statement bundle was slim, and 6 lever arch files, plus 1 thick lever arch of authorities.
Thank you very much indeed. It's very helpful.
Thank you. Well, it won't surprise you that we're going to reserve judgment, obviously, in this case. The draft judgments will be handed out, sent out in the usual way to counsel for correction of any minor factual or typographical errors, not, of course, to re-argue the case. And then the judgment will be handed down in due course, hopefully not under the COVID scheme, but under the old scheme, which, as I recall, would involve counsel not attending unless previously required to attend. It's likely that we would ask you, when we send out our draft judgments, to prepare a consequential order, and if there are any consequential matters to be resolved, pending after judgment, we'd like some written submissions, unless we say otherwise. Is that all clear? I'd like to thank you, all of you, for your hard work on this case. You've been very helpful. Thank you very much.
Scott, those are the footnotes. Can I pass them?
Yes, in fact, I tracked them down from
And
the
I,
original
are you
trial.
marshalling?
They've had the
I'm
authority
staying.
with me, but yeah, that's fine.
Okay. Can I? These are the footnotes.
Grand. Thank you.
Yeah, there's no point in it.